It is 7:50. Jurors in the John Wiley Price trial are having a hard time coming up with a decision. They'll be back at it today after asking the judge for some help yesterday. Chris Lewis is an attorney with Crane, Lewis & Brogdon in Dallas, and he joined us now live. Good morning, Chris.
Good morning.
Can you tell us more on what the judge did? She gave the Allen charge. What is that exactly?
An Allen charge, it's also called a dynamite charge. It's essentially when the jury comes back and says, we are deadlocked, we're not going to reach a unanimous verdict. What the judge does is then reads a charge to them that essentially says, we want you to continue deliberating. If you're not able to come up with a decision, we're going to have to do this process all over again. You are in the best position. You've heard everything. You're in the best position to make this decision. Please continue deliberating as long as you do it to the point where it does not violate your conscience.
It occurs to me that that sort of pressure might have a lot of people get to a point where if they're one of the lone holdouts, maybe it's all by themselves, and they just go, oh, well, the heck with it, I'm just going to go along with the rest of the gang, and that might make the eventual verdict easier to challenge. Am I completely off base here?
Well, it doesn't really make it easier to challenge, but you've got a great point, Dave. I've had a lot of cases like that where, you don't always know what the breakdown is. Sometimes you learn after the fact that there were 10 guilty, 2 not guilty, whatever it was. But the thing that you want to do at the beginning of the trial is you want to empower the jury. You want to say, each and every one of you have your own verdict. It belongs to you. That way, if you get down to this stage, they don't just cave, because if they've been through 5 days of deliberations and some of those jurors are not convinced beyond a reasonable doubt, then that's what their verdict should be, no matter how hard it is.
What do you think they're struggling with? What charges?
I don't know. It would not surprise me if they are struggling with all the charges, just because I think that there's going to be a clear division on those that believe the government's case and those that don't. And I keep coming back to this, just sitting in closing arguments and watching people's body language and watching the jurors' reaction to the presentation from the prosecution and the presentation from the defense, and doing this a long time, you can tell by the ones taking notes, by the ones engaged, that I think that there is a clear line of demarcation between those that are for John Wiley Price and those that are not. And I just don't think that's going to change.
We're talking with Chris Lewis, attorney with Crane, Lewis & Brogdon here in Dallas, and we are talking about the John Wiley Price trial. The jury has been deliberating for 5 days now. They'll be going into their 6th day today after telling the judge that they're having some trouble in reaching unanimous decisions. Chris, you mentioned reasonable doubt, and this is always something that I've wrestled with. I've been in courtrooms, on jury duty. I've never actually been seated on one. But how can we? I suppose at this point, this jury starts to do some soul searching about the definition of reasonable doubt.
They do, and that's the benefit for them of being in federal court as opposed to state court. The definition, we used to have a definition that's included in the court's charge. We used to have that in state court. It has now been removed. So in state court, what you're essentially given is that reasonable doubt is whatever you make of it. In federal court, they're specifically given an instruction that reasonable doubt is it's the type of evidence that you would rely on in the most important of your own affairs. So the way that the defense lawyer brought it up the other day in closing argument, a family member, goes to a doctor. The doctor tells you that you have some sort of debilitating illness or disease. Do you do something based on that at that point in time, on that prognosis, or do you seek a second opinion? This is saying you don't seek a second opinion. You're going to rely on this evidence and these charges and the government's evidence beyond all reasonable doubt, the most important of your own affairs.
All right, we'll have to leave it at there for now. We'll check back in with you tomorrow, and hopefully there'll be a decision from the jury later today. Chris Lewis, attorney with Crane, Lewis & Brogdon.
7:55 right now.